All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning, everyone. Welcome to all parties and participants. Sabah khair. Good morning, Mr. Abderrahman. I will introduce the chamber first. To my right is Judge Antoine Kesembe Mindua. To my left, Judge Tomoko Akane. And I am the presiding judge, Rosario Salvatore Aitala. Court officer, would you please call the case?
Good morning, Mr. President, Your Honors. This is the situation in Darfur, Sudan, in the case of the prosecutor versus Ali Muhammad Ali Abd al-Rahman Ali Koshieb. Case number ICC 0205-0120, and for the record, we're in open session.
Thank you very much. I remind everybody of the need of speaking slowly to allow the best possible live interpretation and transcription of the hearing. Now, I will start with the Office of the Prosecutor. Madam Prosecutor, would you please introduce yourself and your colleagues?
Thank you, Mr. President. Mr. President, the prosecution is represented today by Mr. Julian Nichols, senior trial lawyer, case manager Yasmina Suljanovic, case manager, and myself, Fatou Bensouda, prosecutor.
Thank you very much. Now, Mr. Counsel, defense for Mr. Abderrahman. Please introduce yourself and your colleagues.
Je vous remercie, Monsieur le Président.
Mr. Lauchi, thank you, Your Honor. On the defense bench today, Vanessa Gray, legal advisor, Ahmad Issa, case manager, and I thank the registry for allowing Ms. Marion Caron, who is responsible for analysis of evidence, and our person responsible for language analysis to attend remotely. And as for myself, I am Cyril Lauchi.
Thank you very much. Now the legal representative of the victim, starting with the principal counsel for OPCV, please.
Good morning, Mr. President, Your Honors. A group of victims are indeed represented today by counsel from the Office of Public Counsel for Victims. Appearing in court today, myself, Paulina Massida, Principal Counsel, accompanied by Ms. Sarah Pellet and the third row counsel. Following these proceedings remotely, Ms. Ludovica Vetruccio, Legal Officer, Ms. Mecca Abdal-Garam, Assistant to Counsel, and Ms. Ana Peña, Case Manager.
Good morning. The other legal representative of the victims, please.
Good morning, Your Honours. My name is Amal Clooney. I am the legal representative of the victims in this case, and I am joined today in court by Vera Padberg, legal assistant assistant to counsel, and also remotely on behalf of our team, you have Katerina Lewis, who's associate counsel, Yasmin Chubin, who's also associate counsel, Samas Patel, assistant to counsel, and Patricia Pena, who is our case manager.
Thank you very much. So today we commence the hearing on the confirmation of the charges brought by the prosecutor against Mr. Abderrahman. I remind that at this stage of the pre-trial proceedings, the Chamber will not decide on the guilt or innocence of the suspect. Pursuant to Article 61, Paragraph 7 of the Rome Statute, our duty is to determine whether there exists sufficient evidence to establish substantial grounds to believe that Mr. Abderrahman has committed the crimes with which he has been charged. I will also recall the general principles applying to the present hearing. First, in accordance with Article 66 of the Rome Statute, the suspect shall be presumed innocent until proved guilty before the court. Second, the burden of proof rests with the prosecutor, who, as a result, will have to provide sufficient evidence in order to prove the charges brought against Mr. Abderrahman to the relevant standard under Article 61, Paragraph 7 of the Statute. And third, the defense will benefit of all rights under Articles 61, Paragraph 7, Paragraph 6 and 67 of the Rome Statute. I also recall that while the general rule is that the hearing is public and therefore it is held in open session, it might occur that with a view at protecting private or confidential information, specifically and particularly when it regards victims and witnesses, parts of the hearing may be held in private or in closed session. Pursuant to the order set in the schedule for the confirmation of charges hearing and convening annual hearing on detention, filing 378, dated 5 May 2021, the parties and participants shall have a session of 1 hour to present observations under Rule 122 of the Rules of Procedure and Evidence, as well as responses. The prosecutor and the defense are each granted 4 hours to present their arguments on the merits and 45 minutes for closing statements. The legal representatives of the victim are together granted 2 hours to present their arguments on the merits and 1 hour for closing statements, to be allocated as they see fit. The parties and participants are reminded that the oral submissions of the parties and participants must be concise in nature and repetition should be avoided. In particular, I recall that Rule 122 observations constitute an opportunity for raising issues or objections that were not previously brought before the Chamber, and the parties and participants shall therefore refrain from repeating or reformulating previous submissions. Closing statements may not be used to raise new arguments, but only to respond to arguments and questions raised during the hearing. From a technical perspective, it is recalled that whenever parties and participants refer to evidence, they must indicate its level of confidentiality and specify whether it is necessary to move into private or closed session. Also, when in public session, parties and participants shall refrain from mentioning the names of victims and witnesses and rather refer to their respective codes and pseudonyms. Now, pursuant to Rule 122, Paragraph 1 of the Rules of Procedure and Evidence of the Court, I ask the court officer to read out the charges as presented by the prosecutor. Court officer, please.
Thank you, Mr. President. Summary of charges. The prosecutor brings 31 charges against Ali Mohammed Abd al-Rahman, also known as Ali Koshieb, in particular. 1. Charges 1 to 11 concern crimes in relation to the attacks in Kodum, Bindisi, and surrounding areas between about 15 and about 16 August 2003. 2. Charges 12 to 21 concern crimes in relation to Mukjar and surrounding areas between the end of February 2004 and the beginning of March 2004. 3. Charges 22 to 31 concern crimes in relation to Deleh and surrounding areas between about 5 and about 7 March 2004. The crimes charged as part of these attacks are the following. 1. Crimes committed in Kodum, Bindisi, and surrounding areas between about 15 and about 16 August 2003, counts 1 to 11. Count 1. Intentionally directing attacks against the civilian population as such as a war crime concerning Kodum, Bindisi, and surrounding areas between about 15 and about 16 August 2003, pursuant to Article 82E1. Count 2. Murder as a crime against humanity concerning at least 100 persons, most of whom were 4 who were killed in Kodum, Bindisi, and surrounding areas between about 15 and about 16 August 2003, pursuant to Article 71A. Count 3. Murder as a war crime concerning those civilians not taking direct part in hostilities or persons hors de combat, in particular those persons from amongst the at least 100 persons killed in Kodum, Bindisi, and surrounding areas who were at the material time in the power of the militia, Janjaweed, or GOS forces between about 15 and about 16 August 2003, pursuant to Article 82C1. Count 4. Pillaging as a war crime concerning the looting of food supplies, livestock, medicine, and other property belonging to 4 persons from their homes, shops, warehouses, and other facilities in Kodum, Bindisi, and surrounding areas between about 15 and about 16 August 2003, pursuant to Article 82E5. Count 5. Destruction of the property of an adversary without military necessity as a war crime, concerning the destruction by fire of the homes, shops, warehouses, at least 1 mosque, Islamic books, and other physical structures used by and belonging to 4 persons in Kodum, Bindisi, and surrounding areas between about 15 and about 16 August 2003, pursuant to Article 82E12. Count 6. Other inhumane acts as a crime against humanity, concerning 4 persons who were beaten, verbally and physically abused, and or had to watch women being raped, and a baby being thrown in the air in Bindisi or surrounding areas between about 15 and about 16 August 2003, pursuant to Article 7(1)(k). Count 7. Outrages upon personal dignity as a war crime, concerning 4 persons who were beaten, verbally and physically abused, and or had to watch women being raped and a baby being thrown in the air in Bindisi or surrounding areas between about 15 and about 16 August 2003, pursuant to Article 82C2. Count 8. Rape as a crime against humanity, concerning at least 17 4 women and girls in Bindisi or surrounding areas between about 15 and about 16 August 2003, pursuant to Article 7(1)(g). Count 9. Rape as a war crime, concerning at least 17 4 women and girls in Bindisi or surrounding areas between about 15 and about 16 August 2003, pursuant to Article 82E6. Count 10. Forcible transfer as a crime against humanity, concerning the expulsion of 4 persons lawfully present in Kodum, Bindisi, and surrounding areas between about 15 and about 16 August 2003, pursuant to Article 7(1)(d). Count 11. Persecution as a crime against humanity on political and ethnic grounds concerning the predominantly 4 population of Kodum, Bindisi, and surrounding areas perceived as belonging to or being associated with or supporting the rebel armed groups by means of intentionally directing attacks against the civilian population as such, murder, pillaging, destruction of property, other inhumane acts, rape, and or forcible transfer between about 15 and about 16 August 2003, pursuant to Article 7(1)(h). 2. Crimes committed in Mukjar and surrounding areas between the end of February 2004 and the beginning of March 2004. Counts 12 to 21. Count 12. Torture as a crime against humanity, concerning at least 104 men in Mukjar police station between late February and early March 2004, pursuant to Article 7(1)(f). Count 13. Torture as a war crime, concerning at least 104 men in Mukjar police station between late February and early March 2004, pursuant to Article 82C1. Count 14. Other inhumane acts as a crime against humanity, concerning at least 104 men in Mukjar police station between late February and early March 2004, pursuant to Article 7(1)(k). Count 15. Cruel treatment as a war crime, concerning at least 104 men in Mukjar police station between late February and early March 2004, pursuant to Article 82C1. Count 16. Outrages against personal dignity as a war crime, concerning at least 104 men in Mukjar police station between late February and early March 2004, pursuant to Article 82C2. Count 17. Murder as a crime against humanity, concerning at least 54 men outside of Mukjar between late February and early March 2004, pursuant to Article 7(1)(a). Count 18. Murder as a war crime, concerning at least 54 men outside of Mukjar between late February and early March 2004, pursuant to Article 82C1. Count 19. Attempted murder as a crime against humanity, concerning at least 2 Fur males outside of Mukjar between late February and early March 2004, pursuant to Article 82C1. Count 21. Persecution as a crime against humanity on political, ethnic, and gender grounds, concerning at least 104 males perceived as belonging to or being associated with or supporting rebel armed groups by means of torture, cruel treatment, other inhumane acts, outrages upon personal dignity, murder, and or attempted murder in Mukjar and surrounding areas between late February and early March 2004, pursuant to Article 7(1)(h). 3. Crimes committed in Delhi and surrounding areas between about 5 and 7 March 2004, counts 22 to 31. Count 22. Torture as a crime against humanity, concerning between 100 and 204 males in Delhi between about 5 and about 7 March 2004, pursuant to Article 7(1)(f). Count 23. Torture as a war crime, concerning between 100 and 204 males in Delhi between about 5 and about 7 March 2004, pursuant to Article 82C(1). Count 24. Other inhumane acts as a crime against humanity, concerning between 100 and 204 males in Delhi between about 5 and about 7 March 2004, pursuant to Article 7(1)(k). Count 25. Cruel treatment as a war crime, concerning between 100 and 204 males in Delhi between about 5 and about 7 March 2004, pursuant to Article 82C(1). Count 26. Outrages upon personal dignity as a war crime, concerning between 100 and 204 males in Delhi between about 5 and about 7 March 2004, pursuant to Article 82C(2). Count 27. Murder as a crime against humanity, concerning at least 104 males in Delhi and surrounding areas between about 5 and about 7 March 2004, pursuant to Article 7(1)(a). Count 28. Murder as a war crime, concerning at least 104 males in Delhi and surrounding areas between about 5 and about 7 March 2004, pursuant to Article 82C(1). Count 29. Attempted murder as a crime against humanity, concerning at least 12 males in Delhi and surrounding areas between about 5 and about 7 March 2004, pursuant to Article 7(1)(a). Count 30. Attempted murder as a war crime, concerning at least 12 males in Delhi and surrounding areas between about 5 and about 7 March 2004, pursuant to Article 82C(1). Count 31. Persecution as a crime against humanity, on political, ethnic, and gender grounds, concerning 4 males perceived as belonging to or associated with or supporting rebel armed groups in Delhi and surrounding areas between about 5 and about 7 March 2004 by means of torture, other inhumane acts, cruel treatment, outrages upon personal dignity, murder, and or attempted murder pursuant to Article 7(1)(h). Thank you, Mr. President.
Thank you very much, Mr. Court Officer. Now, the Chamber is mandated under Rule 122, Paragraph 3, before hearing the matter on the merits, to ask the prosecutor and the suspect whether they intend to raise objections or make observation concerning an issue related to the proper conduct of the proceedings prior to the confirmation hearing. I remind that pursuant to paragraph 4, at no subsequent point may the objections and observations made under sub-rule of paragraph 3 be raised or made again in the confirmation or trial proceedings. I also kindly ask the parties to strictly adhere to the allocated time in presenting their submissions. We start with you, Madam Prosecutor. The floor is yours.
Mr. President, Your Honors, the prosecution does not have any observations.
Thank you very much, Madam Prosecutor. Then Mr. Counsel for the Defense, Mr. Lauci, you have the floor to raise any objections or make any submissions if you so wish.
Je vous remercie, Monsieur le Président.
Mr. Lutby, thank you, Your Honor. I do have a number of observations to make under Correction Rule 122.3.
Mr. Lauci, excuse me. Hold on a second, because I've been told that I didn't realize that the legal representative of victims has raised her hand. Please, the floor is yours. Excuse me, Mr. Lauci.
Thank you so much, Mr. President, and apologies for this interruption. I just wanted to complete the process of introductions because my colleague, Mr. Nasser Amin, also wished to introduce himself and his team in the Arabic language. Thank you so much, Mr. President.
Thank you. Sir, the floor is yours. You're allowed to speak.
Mr. President, I would like at the outset to introduce myself. I am Nasser Amin. I'm sorry, the sound is not very good. It cuts out.
We can hear you, sir. Please continue.
I would like to introduce my team. I have Mr. Yahya with me, who is also working with myself. I am Nasser Amin, the legal representative of the victims. Thank you very much, Mr. President.
Shukran. Thank you. Thank you very much. Thank you very much, Mr. Amin. Now, Mr. Lauci, the floor is yours again, please.
Excusez-moi, je suivais l'interprétation en français. Il y avait un petit décalage.
I'm sorry, I was listening to the French interpretation and there was a bit of a lag and I didn't realize that the interpretation was over.
La défense ne formulera pas de
The defense will not be making any introductory remarks during the confirmation of charges hearing. Everything that I am readying myself to say is based on Rule 122.3 of the Rules of Procedure and Evidence, and these remarks have to do with issues dealing with the regularity of the pretrial proceedings. I will make reference to a number of other submissions that have been made earlier. I have 3 points to raise. Fundamentally, first of all, a revelation, secondly, a clarification, and finally, an observation. Now, for the first point, this relates to a confidential and very sensitive issue, so I find myself obliged to ask if the court could go into private session.
Court officer, please, we'll go to private section, into private section.
We're back in open session, Mr. President.
Thank you very much. Mr. Counsel, the floor is yours again.
Je vous remercie.
Thank you. Now, the second point I'd wish to address this morning is a clarification. It has not escaped the defense's attention that your honorable chamber has expressed displeasure with a number of submissions from the defense that the chamber deemed to be redundant or repetitive. I wish to reassure the honorable chamber that anywhere they saw redundancy, or there was actually nothing but consistency in terms of rolling out our defense strategy. One example, Article 115B of the statute. In June 2020, the defense made an initial application asking the court to officially ask the United Nations to make catch-up payments for financial contributions that the court should have received since 2005 to pay for the court's activities in relation to the situation in Sudan, because the activities are based on a United Nations Security Council referral.
L'article 38.3a du statut. Il s'agit de la présidence.
Your chamber requested the application. I then turned to the presidency, and the presidency rejected my application. Duly noted, there will be no UN contribution to the funding of the court's activities in Sudan, contrary to what is specifically set out in Article 115B of the statute. All the same, the defense must raise this violation as part of our challenge of the legality of the UN Security Council resolution, which referred this situation in the Sudan to the courts. We are of the view that there is no jurisdiction. Article 115 of the statute is not a taboo. Compliance with that provision is a condition of legality under the statute. Asking to rule that Resolution 1593 is illegal, and thus the court does not have jurisdiction in this case, that is a request that has nothing to do with the request for the UN to pay the amounts in arrears. This is not redundant. It is merely consistent. But the Honorable Pretrial Chamber seems to see this as a form of redundancy. Yet there is a clear difference, a clear distinction between the two requests. Instead of considering the substance of the arguments regarding illegality of Resolution 1593 on the basis of Article 115B of the statute, the Chamber chose to strongly censure the defense at paragraph 29 of Decision 384. The purpose of these remarks is not to ask you to reconsider Ruling 384. The matter is currently before the Appeals Chamber, but rather I wish to draw the Honorable Pretrial Chamber's attention to the fact that its propensity to reject defense submissions as redundant, and more broadly speaking as defiance that we see in relation to the defense, undermines the regularity of the pretrial proceedings, because the arguments of the defense cannot be considered, the very substance of the arguments are not being considered. This leads me to my third point, which stems from the second, of course, and this is in a number of ways an expansion of my earlier remarks. The prejudice of Pretrial Chamber 2 and its multiple demonstrations of defiance regarding the defense seems to have something to do with a particular view of the scope of the defense, the rights of the defense during pretrial proceedings, And this view is to be found at paragraph 37.
An anticipation of the trial stage, the powers of the party to raise procedural challenges and to conduct investigations must be seen in light of the above and carefully balanced with the right of the suspect to be tried without undue delay, particularly if in pre-trial detention. Ainsi donc,
thus, the rights of the defense that are set out in the statute would be less absolute during the pretrial proceedings and could be restricted, particularly in relation to the right to make applications regarding proceedings, saying, oh, it's not so important, the court will look at these matters during the actual trial. This limited view of the use of the defense's rights has taken material form in the rejection of many applications from the defense. For example, Article 115B, the same thing holds true for the proposed additional principles for reparation to victims under Article 75(1), and the proceedings for admission of victims without the defense having access to their participation forms, and the defense's submissions regarding the historical responsibility taken by the Office of the Prosecutor in 2005 and 2007 regarding the lack of legality of activities undertaken in the field by the court, the danger posed to victims, witnesses, and other people at risk in the Sudan, including the court staff and the staff of the defense teams and the LRV teams, the institutionalized violation of the protection of information policy of the court by the OTP, equality of arms, and finally, the right to appeal decisions taken by pretrial chamber 2. The defense has certainly noticed that the Honorable Chamber 2 did authorize on the 21st of May 2021 an appeal in another case, the Mohammed Saeed Abdelkhani case, on the very same issue raised by the defense in this case regarding the legality of the ABC approach in the system for admitting victims to participate under Rule 89(1) of the Rules of Evidence and Procedure. I refer to decision ICC 0114 012179. I wish the defense team in the other case good luck. We were not lucky enough to bring our arguments before the appeals court. These submissions are not intended to request reconsideration of the various decisions made by pretrial chamber 1, but rather to draw the Chamber's attention to the fact that the restrictions that they are placing on the rights of the defense in this case, saying that these issues are inconsequential for the limited purposes of the pretrial proceedings and could be solved during the trial, also seriously undermine the regularity of the pretrial proceedings and represent an undue restriction of the use of the rights of Mr. Al-Rahman's defense team. The third aspect will also be part of the final assessment of the regularity of the pretrial proceedings by the defense. I have concluded my preliminary remarks under Regulation 1223 of the regulation of, the Rules of Evidence and Procedure. Thank you.
Thank you very much, Mr. Counsel. Now, Madam Prosecutor, you want to respond to submissions of the defense?
Thank you, Mr. President. Your Honors, we don't believe a response is necessary.
Thank you very much. Now, fortunately, we are ahead of schedule, so I will now we will proceed to hearing the submissions in the merits on the merits of parties and participants. We will start with the Office of the Prosecutor. Madam Prosecutor, the floor is yours.
My apologies, Your Honor, if I may. Just for the record of the case, the legal representative of victims from the Office of Public Counsel for Victims has equally no observations or responses following the observation by the defense. Thank you very much.
Thank you very much. And the other legal representatives, do they have any observation?
Mr. President, my position is the same as that of the prosecutor and the OPCV. Thank you.
Mr. Amin?
Mr. President, I do not have any comments either. Thank you very much.
Thank you very much. Now, Madam Prosecutor, the floor is yours.
Thank you, Mr. President. Mr. President, Your Honors, Mr. Ali Mohammed Ali Abdulrahman, also commonly known as Ali Koushib, is charged with 31 counts of crimes against humanity and war crimes. And these include crimes of torture, rape, and murder of civilians in the Wadi Saleh and Mukjar localities of West Darfur State between at least 2003 and at least April of 2004. Counts 1 to 11 concern crimes committed in Kudum, Bindisi, and surrounding areas in August of 2003. Counts 12 to 21 concern crimes committed in Mukjar and surrounding areas in February to March of 2004, and counts 22 to 31 concern crimes committed in Dilij and surrounding areas in March of 2004. Let me now turn to Mr. Abdul Rahman. Feared and revered in equal measure as the Colonel of Colonels, he was a senior leader of the infamous Janjaweed militia in the Wadi Saleh and Mukjar localities during the charged period. During this period, Mr. Abdul Rahman and his Janjaweed militia forces, acting with military and police forces of the then government of the Sudan, attacked predominantly Fur towns and villages. In the course of these attacks, in locations such as Kudum and Bindisi, between about 15 and about 16 August of 2003, civilians were attacked, raped, and murdered. Their homes and villages were destroyed. Thousands were forcibly displaced, and many fled to larger towns, desperately seeking sanctuary. In these larger towns, rather than finding protection, civilians were rounded up, arrested, and detained in various locations. In these circumstances, in Mukjar in late February and early March of 2004, and then shortly after in Dilij, men were loaded onto vehicles, taken a short distance away, and executed in cold blood. Mr. Abdul Rahman was present at and directly participated in these callous crimes. The evidence shows that Mr. Abdul Rahman was a knowing, willing, and energetic perpetrator of these crimes. He played a crucial role, leading attacks, committing murders, and ordering other murders. The conduct that forms the basis of the charges in this case was part of an armed conflict in Darfur between the then government of Sudan, acting together with Janjaweed militia forces on the one side, and on the other, the Sudan Liberation Movement, or Army, and the Justice and Equality Movement. And further, the acts that were charged as crimes against humanity were committed as part of a widespread and systematic attack against the civilian population in Wadi Saleh and Mukjar localities. The victims of the suspects' crimes are countless and their suffering immense. The pain inflicted on the victims of these crimes persists. The region of Darfur is still grappling with the devastation brought about by these events. Entire villages were destroyed. Many inhabitants of these targeted villages remain in camps for internally displaced persons and refugees to this day, 14 years since the first arrest warrant was issued in the Darfur situation. And I stand here today in solidarity with the victims. My office has worked in difficult times and against great odds to come to this point where we are today. But we have remained focused when most had abandoned hope of the progress in the situation, and I've looked at every opportunity to progress the case. Today, Mr. President, is a culmination of those efforts. A hearing on the confirmation of charges constitutes an important and concrete step in the progress of seeking to achieve justice for the victims through fair and transparent proceedings. In this case today, we seek justice for the victims of rape, of murder, torture, and other crimes committed in Darfur. Our evidence we submit will bear out the facts, the criminality, and ultimately culpability in this case. My team and I are ready to present the prosecution's case for the purposes of these confirmation of charges hearings. Mr. President, Your Honors, through the course of the prosecution's submissions, you will hear the accounts of witnesses whose lives have been shattered by the brutality and the mercilessness of Mr. Abdel Rahman and his Janjaweed militia forces. You will hear how the Janjaweed militia employed rape as a weapon to terrorize and humiliate 4 women and girls. Witness P0011 describes being captured by a member of the Janjaweed as she fled the August attack on Bindisi. Let me quote from her statement. He pulled me by the hand and threw me to the ground. He had a knife and used it to cut my skirt. He tied my right leg onto a tree with a plastic cord. He called me wife of Tora Bora. He put that side of his body into my vagina. I screamed, and another Faris, Janjaweed, came with a sword, put it in my mouth, and said he would cut me if I screamed. End of quote. Under my leadership as prosecutor, we have made it abundantly clear that we will, as a matter of strategic priority, pursue those who commit sexual and gender-based crimes and use rape as a weapon or convenient crime in war, and will charge perpetrators where the evidence supports such charges. These crimes, Mr. President, must stop. In another instance, Your Honors, in Mukjar, one foreman later told his family that he was so severely tortured, he would have preferred to have been killed. The torture he endured changed his life, and to this day, he cannot sleep on his back. His injuries are so severe. In Delage, witness 0850 describes traumatized Fur women and children fleeing to Delage after their village was attacked. Let me also quote from that witness. "We were exhausted and extremely hungry and thirsty. Our feet were cut and swollen as we were walking barefoot. My clothes were infested with lice. The children could no longer walk, requiring them to be carried. Mothers did not have enough clothes to cover their babies." End of quote. Mr. President, Your Honors, on a more personal note, I have been involved in investigating and prosecuting this case since the Darfur situation opened in 2005. In this, perhaps my last court appearance as prosecutor of the International Criminal Court, it is my great privilege to be present here today when finally one of the suspects in the Darfur situation is before this court to face independent and impartial justice. Let me express my sincere respect and admiration for the courage, patience, and resilience of the Darfur victims who have waited for so long for this day to arrive. Their patience has not been in vain, and their courage in the face of great adversity, a source of great admiration. I seize the opportunity to express my heartfelt thanks and respect to the inspirational witnesses, the victims, and other individuals and organizations who continue to do everything in their power to pursue justice and accountability for the atrocity crimes committed in Darfur. I will be expressing this sincere sentiment when I visit Sudan, including Darfur next week, in my last mission to the country as ICC prosecutor. The developments in Sudan give renewed hope for justice and accountability for the victims of Darfur, and with this case and these hearings, we have begun that necessary process to achieve that necessary and long overdue goal. To conclude, Mr. President, Your Honors, the evidence in this case will demonstrate that there are substantial grounds to believe that Mr. Abdel Rahman committed the alleged crimes. I respectfully request that this honorable chamber confirm all charges and commit this case for trial. And before I yield the floor, with your indulgence, Mr. President, Your Honors, allow me to introduce the presentations my team will make in the remainder of our time. Mr. Nichols will now provide a brief overview of the case. Mr. Edward Jeremy, who will shortly join us following my departure from the courtroom in observance of the COVID social distancing rules, will address the contextual elements of war crimes and crimes against humanity, as well as the common elements of Mr. Abdel Rahman's criminal responsibility. Ms. Melissa Sims will address the charges relating to crimes committed in Kudum, Bindisi, and surrounding areas. Mr. Pubudu Sachitanandan will address the charges relating to crimes committed in Mukjar and surrounding areas, and also the persecution charges in this case. Ms. Alison Whitford will address the charges relating to crimes committed in Delage and surrounding areas. Mr. Nichols will then conclude the prosecution's presentation. Thank you, Mr. President, Your Honors, for your time and for your attention. Thank you.
Thank you very much, Madam Prosecutor. We take the chance, since it's your, as you mentioned, your last day in the courtroom, to thank you for your service for the court, and the judges would like to wish you and your family happiness and good health and a brilliant career in your future endeavors. Thank you very much. And now the floor is yours, Mr. Nichols.
Mr. President, Your Honors, colleagues, The case we're talking about today focuses on crimes against humanity and war crimes committed in Wadi Salah and Mukjar localities in West Darfur State, Sudan, during the period August 2003 through April 2004. During these months, armed forces of the government of Sudan, along with Janjaweed militia, attacked villages, burned and looted homes and businesses, and beat, tortured, raped, murdered, persecuted, and forcibly displaced the civilians who lived in these localities. The majority of the victims, which form the basis of this case, are from the Fur tribe, the Fur community. One of the persons most responsible for these crimes is in the courtroom today, Mr. Abdurrahman, also widely known by the alias Ali Koushib. At all times relevant to the charges, he was a senior leader of the Janjaweed militia forces in these localities. As Madam Prosecutor has said and we've heard, he's charged with 31 counts of crimes committed in Wadi Salah and Mukjar. He committed these crimes as charged in the DCC and is set out in much greater detail in our pre-confirmation brief, or PCB. In the time we have over just the next few hours, we will show you his individual criminal responsibility for these counts and demonstrate that based on the facts, based on the evidence, the standard of confirmation is met and that the case should be set for trial on all counts. We won't be able to cover all the legal points in the pre-confirmation brief or all the evidence contained in our list of evidence and submitted in support of the pre-confirmation brief and the DCC, and that's part of the record. However, we will try to provide a clear guideline to his criminal responsibility and that the case should proceed to trial. Let me give a very brief background to the armed conflict in Darfur and the setting for this case. In 2003, the government of Sudan had a major problem, an armed rebellion in Darfur. GOS assets, GOS personnel were attacked by rebel groups. The two main rebel groups were the Justice and Equality Movement, or JEM, and the Sudan Liberation Movement / Army, or SLMA. These rebel groups largely drew their membership from certain tribes, the Fur, Masalit, and Zagawa. Just a couple examples of notable attacks by the rebel groups. On 25 April 2003, a serious and coordinated attack on the Al-Fasher airport, in North Darfur. And in the region most relevant to our case today, in July and August 2003, rebel attacks on GOS assets, including police stations in Bindisi and Mukjar. Now, the GOS responded to these attacks with a plan to crush the armed rebellion. The result was a non-international armed conflict in Darfur. And we in the defense have formulated this in agreed fact number 1. However, the GOS plan and response also relied on and incorporated an attack on the civilian population in Darfur, as the Fur, Masalit, and Zagawa were perceived as supporting the rebels. And the GOS, the government of Sudan, decided to deploy irregular forces, Janjaweed militia, largely drawn from Arab tribes, in order to supplement the regular armed forces at their disposal of the government of Sudan. And the state policy of the government of Sudan, which Mr. Jeremy will discuss in just a few minutes, probably right after the break, included the use of these Janjaweed forces. We've set this out in our pre-confirmation brief at paragraphs 23 through 26, where we state, in part, the attack against the civilian population was not spontaneous or isolated acts or violence. Rather, the attack was carried out pursuant to and in furtherance of a state policy by the government of Sudan to commit an attack against the civilian population in Wadi Salah and Mukjar localities of West Darfur. Further, we state an integral component of this campaign was the use of GOS forces and members of Arab tribes, in particular militia Janjaweed, to target villages and civilians that were perceived as being associated with or supporting the rebel groups. That's from paragraph 24. Now, importantly, this state policy is clearly reflected in the National Security Plan of the government of Sudan for 2004. Mr. Jeremy will discuss the state policy and the national security plans and detail how they included the targeting of 4 Zagawa and Masali villages and the assassination of community leaders, or umdas, and others who were considered to be sympathizers to the rebel groups. I'll now turn to the defendant. Mr. Abdul Rahman, widely known during these events and later as Ali Kushayb, was one of the principal and notorious perpetrators of these crimes. Now, he contests his alias, but there's no mistake. Mr. Abdul Rahman is the man who was known as Ali Kushayb. Ali Kushayb, the person known as Ali Kushayb, is in the courtroom. The evidence that Mr. Abdul Rahman was widely known as Ali Kushayb during the material times set out in our filing to the court of 7 December 2020. There's also some more information in the citations to footnote 1 of our pre-confirmation brief, and I won't repeat that information now. As you hear our submissions today, Your Honors, we would ask you to consider Mr. Abdul Rahman, his position, his role as a senior Janjaweed leader, respected and feared, who commanded thousands of troops during the charged crimes. He was the strong man in Wadi Salah and Mukjar. Consider his statements and his acts. His criminal intent and conduct is clear, as he personally beats and murders prisoners and orders a firing squad, quote, "Don't leave me one person alive," end quote. Look at the part he plays, Mr. Abdul Rahman, Ali Kushayb, to his associates and to his victims. What he says and what he does during the criminal events that we will discuss today. Now, let me try to show you on the screen the area where the crimes were committed. And I'm not sure, I'm sorry, what I need to do to broadcast this. I thought this was ready to go. Is the slide showing on people's screens? Thank you very much. Now, first, we have the map of Sudan of 2000 as the boundaries were in 2003 and in 2004. Which have changed, of course. Next, in the blowout, we can see a detail of the area of Darfur to the west of Sudan. And next, West Darfur, the state of West Darfur. And in the rectangle to the south, you can see the highlight where Wadi Salah and Mukjar localities are located. West Darfur, to give you an idea, had a population of approximately 1.7 million, the majority of which were Fur. And in the rectangle where we see the borders of Wadi Salah and Mukjar localities, that area compromises approximately 1,400 square kilometers. I'll now outline just a few examples of the evidence of the crimes committed by Mr. Abdul Rahman in these locations, all detailed in our pre-confirmation brief that you will hear about today. First, chronologically, the attack on Kadum and Bindisi and the surrounding areas. This attack took place between about 15 and 16 August 2003. Abdul Rahman leads the convoy into the attack of armed Janjaweed and GOS forces on the civilian population, where, as set out in counts 1 to 11, at least 17 women and girls raped, at least 100 persons, including men, women, and children, are murdered. The surviving civilians are displaced, their property is stolen or destroyed. You will hear from Ms. Sims when she discusses this crime base in greater detail, that Abdul Rahman led this joint attack, which consisted of heavily armed Government of Sudan forces and Janjaweed troops who were in land cruisers as well as on camel and horseback. One witness during the attack saw these attacking forces fire on fleeing villagers as they were trying to run away, and that these people were shot at, quote, from all directions, end quote. And he continues, quote, the revenge of Ali Koushib and his comrades against the village of Kadum was immense. The witness also saw dead bodies in the street. And as set out in paragraphs 187 to 192 of our pre-confirmation brief, the forces led by Abdul Rahman in this attack stripped women and girls of their clothing and raped at least 17 victims. And you'll hear of the evidence that at this time, as the victims were being raped, a witness heard some of the attackers fire their guns in the air in celebration and shout, "I have found a virgin woman." Next, moving chronologically, I'll briefly address the crimes committed in Mukjar and just outside of Mukjar. These crimes were committed in late February, early March 2004. You will hear Mr. Sachithanandan describe how 4 men were held in the police station in Mukjar and other nearby detention facilities in horribly inhumane conditions. He'll take you through the evidence that Abdul Rahman beat prisoners, selected prisoners for execution, ordered the execution of prisoners, and that ultimately at least 50 detained 4 men and some boys, and when I say boys, I mean children, were murdered. A witness present at the police station in Mukjar, where many of these 4 men were held prisoner, saw Ali Kushayb personally beat detained 4 community leaders, known as umdas, while other assailants cut the ears off of 3 prisoners. Another eyewitness describes how a convoy of prisoners was taken away from the detention sites in Mukjar, out of town, where Ali Kushayb ordered that the prisoners be taken off their vehicles and shot. At the execution site, Ali Kushayb ordered the shooters to continue firing at the prisoners, saying, quote, "Repeat, repeat for these people. Maybe there are some you have missed." End quote. Another victim, an elderly sheikh, asked at the execution site for permission to say a final prayer before being killed. Abdurrahman allowed him to do so. And after his prayer was concluded, this elderly man, too, was shot and murdered. And who were these victims? Detained, beaten, loaded onto vehicles, taken out of town, and then murdered on Abdurrahman's order. The evidence is that they were simply farmers, traders, other forced civilians, many of whom had been displaced from their homes in earlier attacks, fled to Mukjar in a failed attempt to survive. I'll be done soon, Your Honors. Finally, Delej and the areas just outside, shortly after the crimes in Mukjar. These crimes are set out in counts 22 to 31 and were committed between about 5 to 7 March 2004. And I think you will see that they follow a similar pattern to the crimes that were committed just a short while earlier in Mukjar. In and around Delej, Abdurrahman beats detained Fur men, personally murders Fur prisoners with his axe, supervises the process of prisoners being forced onto vehicles for transportation outside of town to execution sites, orders the execution of the detainees, resulting in the murders of at least 100 Fur males. Miss Whitford will discuss these crimes. She will tell you of one terribly injured victim of the Delez mass executions. Abdullah Musa, also known as Malenkwe. I can say his name. I don't have to say a P number because he's dead. He lived long enough to tell his story of what had occurred that day to him and others before dying from his gunshot wounds. Another eyewitness saw his father and brother arrested by Ali Kushayb in Delej. Days later, this witness personally found the bodies of his father and brother laying in the open amongst the corpses of other victims of Ali Kushayb's executions. Now again, as in Mukjar, who are these people? They were victims who'd been displaced from their homes and other villages in earlier attacks, who had fled to Delej. Mainly 4. And again, as in Mukjar, you will see the evidence shows that community leaders, umdas, were especially targeted for victimization. Today, Mr. President, Your Honors, in the presentations that will follow, we will discuss first the perpetrator, Mr. Abdurrahman, known as Ali Kushayb, who he is, Mr. Jeremy will discuss his background and briefly his military history, his medical background, and his pharmacy in Garcilla, where he was based, his local leadership position and authority in the Janjaweed, his position and role in these events, the Agid al-Ogada, the colonel of colonels, the highest colonel of the Janjaweed forces in Wadi Salah and Mukjar localities, and his critical role as the link between the government of Sudan and the Janjaweed during this campaign, and also his close relationships with personnel in the government of Sudan and government of Sudan armed forces, and in particular and including with Ahmed Haroun, then the State Minister for the Ministry of the Interior of Sudan. As we set out the facts of the case today, what happened in Wadi Salah and Mukjar localities from August 2003 through April 2004, we invite you, Your Honors, look at Abdul Rahman's senior position, his authority and his power. Look at his central role. Look at his statements and look at his acts. His acts in relation to Kundum and Bindisi, in relation to Mukjar, and then in relation to Delej. What is he doing? What is he doing from August 2003 through April 2004? He's leading the attack on the civilian population. He's leading the convoy of Janjaweed and GOS forces into Kundum and Bindisi, shouting to the troops, quote, "Wipe out and sweep away, wipe out and sweep away," after which the attackers murder, rape, and displace the civilian population, pillaging and destroying their property. He is inflicting severe violence on civilians, beating prisoners. In Mukjar and Delej, he is literally hunting down displaced men from earlier attacks. He murders prisoners directly himself with an axe. He supervises the transportation of victims to be killed by others. He orders that they be shot and killed, and watches as they die, and demands that there be no survivors. If you consider the facts, you consider the evidence discussed today and set out in our pre-confirmation brief, we believe you will find that there are substantial grounds to confirm all 31 counts in the DCC, and we ask you to do so. I'm finished, Your Honor, and I think we're at the break.
Thank you, Mr. Prosecutor. Before I adjourn the hearing, for the records for the parties, let me say that the Chamber is taking notes of the observations of the defense under Rule 122, and the Chamber will rule on them in the confirmation of charges decision. Now I adjourn the hearing for 30 minutes. We then will resume at 11:30. Thank you very much.
All rise. Veuillez vous lever.